And I'll also mention that I'll move on to the next slide, actually, just to talk about the topic for the day. These are the topics for today, all to do with IP searching. And I should just mention up front that this is fairly heavily biased towards patent searching, but we certainly don't want it to be limited to that. So if any of you have got questions about other types of searching, particularly trademarks and designs, one of my colleagues, Laurie Bray, who's a trademark attorney, is on this call, and she'd be happy to answer questions during today's talk. And equally, if you're interested in a specialist webinar on trademark searching, then I'm sure that's something we can add to the series. So thank you, Laurie, for joining us. So these are the topics for today. I won't read them out. You can see them, but this is what we're trying to cover today. And as I said, Alec and I will alternate between discussing the various elements of the talk. So moving on to IP strategy. I guess the point here I wanted to make as a sort of scene setting is that IP searching is one element of what needs to be an overarching IP strategy, and it's not distinct really from the rest of your IP strategy. And it's very important to understand that, like all elements of IP strategy, searching is something that sits sort of at the hub of your business, as shown in this picture. So it's something that touches on all of these functions of your business: legal, financial, commercial, technical. And each of these functions have different views on IP, different things they want to get out of it. And when you're putting together an IP strategy, as I explained in a recent webinar, you need to be talking the language of all of these different people. So it's really crucial that when you're putting together any element of IP strategy, and searching is a particularly important element of that you're doing things that these departments understand and that they can make a business use of. So legal might want to know about the risk side of searching, and technical might want to know about the opportunity side. So it's really important that you're looking and speaking their language. So moving swiftly on to different types of IP searches. I'll be talking about a couple of types of IP search initially, and then I'll hand over to Alec, who will discuss some of the nuts and bolts of particularly patent searching. But what I'm covering here are when people talk about a patent search, this is often what they mean, what we call a novelty search. So a novelty search is a search for any type of IP, registered IP, inventions, designs, trademarks, which is seeking to answer the question, is my invention new? Is my trademark new? If so, it might be worth registering. And unlike other types of searches you'll see later, it has particular characteristics, as you can see here. Searching all literature, it needs to be worldwide, can cover prior use as well as publication. You're looking backwards in time forever. I've seen publications from the early 1900s cited against patents. Date should not be a limitation, and the costs can be relatively low depending on the strategy. Like any search, and a novelty search, you get what you pay for. So for example, as I mentioned at the end here, novelty searches form part of a patent registration process. And a design registration process sometimes, normally not, but certainly with patents there are novelty searches done by patent offices. So it's often a question that I'm asked, which is why should I do a novelty search before I file a patent? Because the patent office will do one themselves. And again, there's no wrong or right answer to that question. When I'm drafting a patent application, I will always do what I call a quick and dirty search. In other words, I'll get onto Google and I'll use some of the free resources that I'll mention later in the presentation. So some level of novelty searching before you file a patent application is always worth doing, I think, but it's always a question of time and money, as with everything. And during the registration process, you'll have patent office searches which do the job for you. But even those patent office searches are not perfect. I mean, I know patent seekers, Alec, that you'll do novelty searches at various levels for clients, often pre-filing. That's right, isn't it?
Yes, that's right. We offer a range of novelty or patentability type searches that cover a different number of days, as well as increasing depth and number of commercial databases searched. So like you said, it really is depending on budget, really, how much we do and how much you're willing to invest in the pre-filing search.
Thanks, Alec. And the other thing I'd mention about pre-filing searches is that it's absolutely crucial, in my experience, that you do them at a point when you actually have a rough idea what the invention is. I've seen my fair share of pre-filing novelty searches which have been done before anybody had a very clear idea on what the invention was. So, for example, I've had ones where, you know, an invention has been sent to me to write a patent, and they've sent me the results of the search, and I've looked at the search and I've said, well, they were looking in the wrong place. And I immediately went to Google, put some keywords in, and bang, some very relevant prior art came up. So, you know, searchers are not often patent attorneys. They're not often qualified in terms of identifying inventions. So they're pretty good at it, but some thought you don't necessarily need to bring a patent attorney in at that stage, but you do need to have a very clear idea what it is that you think is the unique bit that you're looking for, because that will obviously dictate the quality of the search. And as Alex said, it's all about budget and time, and you don't want to be spending months doing a novelty search and holding up the filing of a patent application, because that is potentially fatal to the application. So yes, they're worth doing, but you know, within a limitation. The other thing to mention here is a thing called the US duty of disclosure. So if you file a US patent application, you need to let the patent office know about any results of any searches that you've done relating to that invention. So it's very important to understand that, and if you've done a search like this, it's very important to keep a careful note of what you've learnt and to make sure that that gets volunteered to the US Patent Office, because if you don't, it could make that US patent invalid. So you know, that might be a reason not to do novelty searching, at least not at this stage. So that's novelty searching. And as I said earlier, we'll mention some various resources that you can use to do them yourself. And of course, there's good old Google, quite apart from patent searching. So moving on to the next type of searching, invalidity searching. Very similar in many ways to novelty searching, but you're doing this to answer a different question. You're looking to answer the question, is a patent valid? That could be your patent, or it could be somebody else's patent. Most commonly, it's somebody else's patent, where you think you've got a problem, that you infringe it, and you're looking to oppose it, to cancel it, or somehow modify it. And so you go out there looking for prior art, as we call it, which is previous publications or use of the invention, which predate the earliest filing date of that patent application. So you can see that this will have a very, very similar characteristics to a novelty search, but with some maybe quite important differences in that you're looking back from the priority date of the patent. So you're not looking back from today, you're looking back from a specific earlier date, which could be many years earlier. And the other thing to bear in mind that you're really just remember, there will have been novelty searches done during the patent office registration process. So you don't want to be reinventing the wheel here, or rediscovering prior art that the patent office has already found. So my strategy with invalidity searching and just generally opposing patents is, before you go anywhere near an invalidity search, you want to look at the prior art that has been cited in the patent office searches. Because quite often patent offices find prior art and don't spot quite relevant bits of it. So it's a very common thing. And so that's the first thing I would do when I'm looking to invalidate a patent, is look at the file history, as we call it, the previous searches by the patent offices, to see what's out there and see if there's some ammunition there, and then present that information to the searcher that does the invalidity search. So you're not asking them to come back with what you already know about, but you're asking them to sort of supplement what's already been done by the patent office search. The other thing I'd say about invalidity searches in general, and opposing patents particularly, is that in my experience, often the best prior art you can find is quite difficult to find by conventional searching techniques, and can often be, if you've got an expert on hand who knows where to look, they can be very useful people, particularly people with in a particular technology. So with one of my clients, they have engineers who go way back, and I usually have a go-to person who I'll ask, well, have you seen this before? And they'll say, oh, they'll pull out a sort of dusty magazine article from their desk. Of course, this is back in the days when people worked in offices with desks, but that type of person, if you've got them on tap, they can often be the most useful source of information before you sent it out to a professional searcher like Alec to do an invalidity search. But it's still worth doing that, and I'll give you an example of when, in my experience, when that is also worth doing, because I had a patent recently where my client was worried about infringing. So we had a look at opposing the patent, and we looked at the patent office searches, and none of the prior art was particularly relevant. And I sent an invalidity search off to a searcher, and I said to them, well, it's probably not worth bothering looking at patent literature very much, because we've had searches done by the Japanese patent office, the European patent office, the US patent office, and there's a good chance they will have found any patent that's relevant. So please, can you go looking particularly for what we call non-patent literature, which is prior art that's, you know, magazine articles or textbooks and the like. But of course, sensibly enough, the searcher didn't do what I asked them to do, and they actually did look for patents. And lo and behold, they found an incredibly relevant piece of prior art that had been missed. And the reason it had been missed is that it was a Spanish patent application that I presume had only recently been machine translated. So probably at the time the searches were done, probably 10 years ago, this particular piece of prior art had only been on a database in Spanish, and so it hadn't come up in keyword searching, whereas we'd updated the search 10 years later, and at that point the databases had been populated with a machine translation. And I think, as Alec could probably comment, you know, we've got vast amounts of machine translation searchable in English patent literature available to us today, which wasn't available 5 years ago. That's right, isn't it, Alec?
Yeah, it certainly makes our job significantly easier. And I just to add as well, like you said, is the invalidity searches are very useful when you're afraid of infringing, but then in the slightly different scenario, it's also a very good first line of defense if you've been accused of infringing. And again, the other side of the coin to an invalidity search is, which you touched on earlier, Jim, is what we call a patent strength analysis. So it's where we try to invalidate your patent to see how strong and how robust it is and how it stands up to any professional searcher.
Yes, absolutely. So yeah, that's invalidity searching, and as I said, it's similar in many ways to novelty searching, but again, I think it's, in my experience, invalidity searching is best not done by just throwing a patent at a searcher and say, please go and search that. I think a little bit of, and probably Alec would agree, I think a little bit of pre-analysis is always helpful, and also to make it an iterative thing. So if the invalidity search comes back and the invalidity search kills a broad aspect of the patent, let's call it claim 1 of the patent, you might want to go back to the searcher and say, well, can you go and focus in on claim 6 or claim 7, some specific aspect of this patent that we want to invalidate, because that might be the thing that you're ultimately going to be infringing. So these things can be an iterative process rather than just one shot.
Definitely. And it's worth, like you said, it's worth doing that little bit of extra research, looking at examiners' comments where available, looking at why certain claims weren't allowed or why they were allowed can really help shape the search in the right direction.
Okay. So I think, over to you, Alec.
So in case anybody didn't get that, my name is Alec Griffiths. I'm an IP manager at Patent Seekers. We've got over 15 years of experience providing universities, major companies, lone inventors, all manner of searches from novelty, FDO, invalidity, patent landscape, and monitoring searches. We're approaching close to 20,000 searches now. And we've recently, last year, opened an office in North America in Toronto. I think one of the main things people seem to like about Patent Seekers is our responsive customer service. We're very quick to reply to quotations, often within the same day. If it's sent late in the day, then it'll be the next morning, and the same with any queries you may have about searches. I'm just going to take control now and just offer a few tips and hints I've learned and some of the potential pitfalls to avoid over my time at Patent Seekers and patent searching in general. We're going to briefly cover research and keywords, everything there. So to start, a patent search is probably only as effective as the keywords used in that search. This is why it's of paramount importance to get this part right. This is the first stage. The easiest way to start is by making a list of everything that your invention embodies, the main embodiments. And from there, you can start to generate some suitable synonyms to make sure you cover all the bases. As an example on the slide, if your invention relates to a car, then you're going to want to search for terms such as vehicle and automotive. A helpful practice is to check patents in the area of your technology. This could just be through some initial searching, or it could be if you're having trouble by thinking of a major company in the field and taking a look at how they describe their patents. You'll probably find that you'll find patent language that is not quite, that describes a certain invention in a way you weren't expecting it to be described. For instance, a toothbrush is quite commonly described as an oral hygiene device. And so just by searching toothbrush or words that just common words, you wouldn't quite pick, you probably missed quite a lot of the prior art. Truncation and proximity operators both are going to be used to increase your search efficiency. They do both have drawbacks if not used correctly, which I'll touch on in a moment. But essentially, truncations, or when you truncate a word, they'll often use a symbol on the database, such as the star, a hash, or a question mark, that extend your keywords. So if we put the truncation on the word electric, as the example shown, it'll pick up the word electric, electrically, electrics. And this differs between databases. Each symbol searches for differing degrees of extension. Make sure you check any help pages just to make sure you know exactly what your search covers and what it won't cover. The major drawback with truncation is, in some instances, it can widely explode this number of search results you receive from a search. For instance, the word car. You should be careful with truncating the word car, because if you use the wrong truncation, then you could be searching for words such as care or caring or carapace, and they're definitely not going to be relevant to, or most likely not relevant to, any invention that relates to cars. As a general rule of thumb, it's probably best to use smaller truncations on three-letter words such as car and tab, for instance. Proximity operators are another tool you can use to really focus your searching, and essentially it limits the distance between two or more keywords. So if you were searching for electric cars, you could use a proximity operator to make sure you picked up the word electric within a set number of words of car. Again, the drawback with this is you could be over-limiting. So if you looked for electric within one word of car, you could quite easily miss patents that describe the invention as an electrically powered car. So patent classifications assigned by the Patent Office to each patent. Most often, there's quite a few classifications per patent, and they serve as a means to collate patents according to the technology they disclose. These same classifications can also be a useful means to narrow down and focus your searching, helping you find related subject matter much quicker. There's a number of different patent classifications out there. I would say the main three are IPC, International Patent Classification, Cooperative Patent Classification, the CPC, and the US Patent Classification, the USPC. The way patent classifications are constructed is there's a series of what we call parent classifications, and each of these relates to a broad area of technology. And then within those areas, there could be thousands of individual breakdowns that refine the subject matter further and further until you find something potentially that is exactly the same field as what you're looking to invent in. And then it will really help you then find some relevant subject matter. Classifications can be searched independently. A useful way of searching them is to search a breadth of classifications that all disclose a similar subject area, and then you increase your search efficiency by doing so. It's also very useful to search for the overlap between classifications. So if you were looking for a walking stick with a pedometer, then you could look for the overlap between a walking stick classification and a pedometer classification. And that's a really useful way, again, to help you alleviate some of the problems that could come up with just keyword searching, if your keywords weren't broad enough, or the patent language was such that it was described in a way that you'd never heard before. Most, if not all, of commercial databases will have a classification tree, and this will allow you to search through yourself to look for, if you don't have any patent material to base your classification search off, this will really aid you in that matter. It is important to note, though, that classifications are assigned by the patent examiner and the patent office, and therefore they can be subjective. Patents can also be reclassified as new classifications are created or older ones are no longer used. So it's very important just to be aware of the drawbacks in those instances.
I was just going to say, Alec, just to comment on, I mentioned earlier the quick and dirty search technique, and which, as I said, I sometimes try and spend 10 or 15 minutes, probably no much more, having a quick look. And one technique I sometimes use if I want to do that as quickly as I can is just to use keywords initially. And I might get a very long list, but then I'll probably quite quickly be able to pick out one or two from that list that look bang on, or at least in the right area. And then I use that as a way into the classification structure. So I'll click on those two and say, okay, how are they classified? Okay, it looks like I need to be looking here. So that's a quick way in, rather than actually trying to start with a classification sort of index and trying to use that to find it. It can take a little longer.
It's much more helpful for you to have a set of patents, like you said, to base your classification search off. Again, it's also very useful because there are thousands of breakdowns for all the different areas of subject matter. So if you can very quickly and very easily find patents in the area, you're adding that extra layer of guarantee that you're going to search all the correct classifications. Once you've this could be done before or after you've found relevant results. If you look at the assignee or inventors or the citations of those relevant results, then this can often lead to additional relevant results, because quite often the inventors will work on the same type of subject matter. A certain assignee will be prevalent in a certain field. And of course, the citations are just very useful to help uncover other relevant results, other classifications. All these useful tips that I've just mentioned, they all sort of play into each other during a patent search, and everything cooperates to find classifications, keywords, and the search. It's very important to develop your search as you're going forward after finding all this useful information. And by the end of your search, you should have a plethora of extra keywords, classifications, ideas of the main competitors in the field. And this could also help you find companies that aren't obviously involved in the tech, that you weren't aware of. They could be subsidiaries or parent companies that you didn't realize originally that the patents were in those names rather than their subsidiary, for instance, that actually sells the product or markets the product. I'm just going to hand you back over to Jim now.
Thank you, Alec. And I'll just mention, you refer on the previous slide to citations, and another element of citations is probably worth mentioning is a thing called a forward citation search, which I think can be quite useful, which is a search where you're looking for other people who have cited your patent as prior art. So it's very different from a novelty or invalidity type question. You're looking for people who have effectively built on the technology that you've invented. So it's looking for future later file patent applications that refer back to yours, and that can be a really useful tool to pick up on potential collaborators, or so you're not looking for infringement risks. You're looking for you're looking for people who have cited your patent. So I think we've lost the presentation. Let me just reload that.
Oh, my apologies. I may have hit something.
Okay. That's okay.
Inadvertently.
I'll just reload that. Looks like we have a dog on the call.
That is outside, unfortunately.
So once it's loaded, I'll take you to the next slide, which is on freedom to operate searching. So we've talked about searches which are looking for, just to remind you, novelty searches and invalidity searches, which are looking at the question of patent validity or invention or trademark validity. FTO searches, freedom to operate searches, are very different. And it's very clear, very, very important with these in particular to have a very clear idea why you're doing it. So you're looking to answer the question, am I free to operate? For instance, by selling a product or service. And this can obviously apply to trademarks, registered designs, or patents. And so it's answering a very different question, and it's a very, very different type of search. And it's important not to get confused between the two. It's different in many ways in terms of the strategy. You're looking at particular countries where you intend to operate. So you can't really, in a reasonable budget, do an FTO search, which is worldwide. You need to be saying to yourself, okay, we want to open up, start selling in the US. That's where we want to do our FTO search. So you're looking for US patent registrations in that case. And again, you're not looking at any literature; it's just patent literature. So of course, the actual search pool of things you're looking at is much smaller. But there are other things you need to check, as well as the disclosure of the documents. You're looking to check their status. Are they still alive? Are they so old that they've fallen away? They're more than 20 years old. In the case of patents, they'll no longer be in force. And you can use sort of date limitations to exclude these very old and lapsed type of publication. They can be expensive, and so it's very, very clear, as I say in the next slide. It's very important to understand, if you like, to be prepared for the wrong answer. What I mean by that is, when a client is contemplating a freedom to operate exercise, I always take them through a kind of decision tree, a sort of a tree of possibilities that this search could end up with. So if you get to the end of it, there are a number of outcomes, which could be you're absolutely fine, no problem. You definitely infringe a patent, or there's the grey area in the middle. There's usually quite a few different possibilities, and if you don't have a very clear idea in advance what you're going to do with the result of an FTO search, then I say don't even bother doing it in the first place. And I'll give you some examples of searches which are really effective. I had a client who had 4 different possible designs for a particular product that they were contemplating. They were quite mature designs, and they'd run them all in parallel, and they'd got to the point where they needed to make a decision. So there were technical questions around which were best technically, but they wanted to ask the question, do any of these present us with a patent infringement problem? And it turned out that one of them certainly did, and one of them certainly didn't, and then there were 2 in the middle. So that really helped their process for choosing one of these designs. And so there was a very clear business outcome to this search, and clearly a very valuable business decision that they made as a result of that search. So that was money really well spent. On the other hand, the other end of the spectrum, you have companies where they say, let's do an FTO search, let's spend £10,000 plus, let's say, on this exercise. You get to the end of it and you say, okay, we found this patent, we think it's a problem. And the client says, okay, well, that's nice, but we're going to do the same. We're going to carry on anyway. Well, they could have made that decision before spending the money. So it's very important to think to yourself, what are we going to do with the results if it's a bad result? If there's a problem, are we going to give up and move on? Are we going to take a license? Are we prepared to take a license? Is there enough money in this product? Can we charge a premium so we can afford the license charge? Do we have the ability to design around the IP if you find a patent that's a problem? Do you have any wiggle room? Can you make design changes? The example I gave was a really good one. But if you're in a cul-de-sac and in a place where you can't move anywhere technically, then either don't go looking and just live with the consequences, go and buy some insurance against patent infringement or whatever, or do the FTO search, but be prepared to act on the result. That's the key point here. Be prepared to act on the result, and if you're not prepared to do that, don't even bother. Okay. Please do yell out with any questions, by the way, as we go. I will be asking for questions at the end, but please don't be shy if you'd like to ask any questions. Okay. The final type of search I'll touch on is what we call landscape searches, and probably Alec can explain a bit about this. But these are looking for you're looking for the landscape in the sense of what's new and what's out there, and where are my competitors moving? Where is the white space? In other words, where are the areas of technology where people aren't innovating and there aren't many patent filings appearing? It's limited to registered IP, so it's not looking at all publications. It's usually using patent classifications that Alec mentioned earlier, sometimes with keywords. And you're normally only interested in the most recent publication, so you may limit it to the last year or so. So it's a type of search that can be very helpful as a piece of information for your R&D department to understand where looking for opportunities in terms of white space. Okay, maybe there's some white space here I can go and innovate in. Here is some very congested space where maybe I should stay away. Or maybe you're looking for, maybe you want to move towards the congested spaces. All sorts of things you can do with that information. But like with any type of IP search, only worth doing if you've got the bandwidth and the people with the time to actually make use of that information. It's with engineers who are actually going to pay attention and again make a business decision or a technical decision based on what they find. They can be relatively cheap, and they can be supplied in a quarterly way or at any frequency, and you can do them yourself, or you can outsource them to patent seekers or other organizations. It's something you do, presumably, Alec, at patent seekers, this type of thing.
Yes, yeah, we do both ends of the spectrum. So monitor publications put forth by certain companies and applicants in certain patent classifications on a monthly, quarterly, or biannual basis, as well as helping companies try to identify the white space, really. And one of the key things about landscape searches in that regard is that if you're keeping it to the most recent publications or a certain patent classification, you can afford to be quite broad, and we can afford to be quite broad. And a sort of sweeping brush type approach to try and find everything based in the general area, and then feed that back to yourselves, who can then make quite an informed decision as to what is being protected, what might be protected, which direction you can go.
So finally, one thing I'm very keen on my clients doing is doing their own searching and developing some sort of knowledge within the company to do some searching, and as I said earlier, you don't need to spend huge amounts of time on it, and it can be, there's no substitute for experts to do proper searches, but there's internal competencies, and I'm sure the people who are attending here are interested in this. Inventors and designers, the marketing department. If the marketing department are looking to understand where the market's going, patent literature can be a very useful way of doing it. Looking for infringements. And if you think about it, one of the functions of the patent system is to put out there information that wouldn't otherwise be put into the public domain. That's the trade that you're doing when you're filing a patent. It's in return for disclosing the details of the invention to the world, you're getting a monopoly for 20 years. So it's that patents are there to be searched, and they're a tool that companies can use. You'll find stuff in patents that is very well hidden, but can be incredibly useful in terms of getting intelligence on your competitors or understanding where the market's going. So some of my clients have fully fledged search departments within the company, whose job is to keep an eye on the landscape, to look for infringement risks and do all the things we've been talking about here. But you don't need a big shiny search department to do very effective patent searching. you just need to spend an hour or two attending webinars like this and learning the ropes, and it can be very effective. Patent attorneys can help you and give advice, but we're not the experts in the art of searching, unlike Alec and his colleagues. So I'd urge you, those of you who are here, to sort of spread the word in your organisations about patent searching and how useful it can be. I think I've got one more slide just to talk about cheap or free IP search resources. There are, of course, plenty of not cheap IP search resources out there. And of course, that might be appropriate depending on what you're looking to do with them. But there are plenty of resources out there which you can use to at least learn the ropes and understand the art of searching before you start spending serious money on it. And Espasnet I've listed there as being, one of the, in my experience, the best free. That's free. It's run by the European Patent Office. It's got 120 million patent documents on it. Full text searchable. As we said earlier, many machine translations being uploaded to it daily. Vast numbers of recently Chinese utility models I'm experiencing getting uploaded to that because that's been the big boom in the last few years. But that's fine. I mean, that's good information, and it's pretty easy to navigate. And it's something that in the profession we use all the time. You can download PDF copies of documents. It's really very good. And only recently has it become full text searchable, which it wasn't always. So it's a wonderful free resource provided to us by the European Patent Office using our official fee money to do something useful for us. And it's a really good resource. So I'd urge you, and this is something that I try and help my clients to understand how to drive Espasnet, and it's something that's very, very good. Again, if you're looking for FTO information, freedom to operate information, the various patent offices and registries have fairly good search functions, although some are better than others, I think. So EU IPO, if you're looking for trademark registrations and design registrations, that's the place to go searching for that sort of thing. Google has a particular patents search functionality. I'm not a massive fan myself. I don't know, Alec, whether that's got any benefits over Espasnet. I tend not to bother. Some people are slightly paranoid about Google putting if you put all the details of a new invention into the search bar, they worry that Google are going to be sucking up this information and using it in some nefarious way. I'm not so worried about it, but yeah, I don't know whether you have a view
the infamous Google trap.
Yeah,
that doesn't exist anymore though. So well, you can be quite safe and rest assured that nobody's going to be stealing, or Google won't be stealing anything.
I think that's likely. But yeah, as a search function, I find it less, not as good as Espasnet in my experience. I don't know what you probably don't use either of them, Alec, probably, but
no, we do use Espasnet, but yeah. Yes, I do find it personally better than Google Patents. With databases, it's all about the trade-off. So, like you said, there's many that are very, very expensive, and then there's some that are free. And the important thing to note is, if you're using just free resources at any stages, they do have their limitations, and that is why they're free. Espasnet is very comprehensive and it is very good, but it still comes with its own limitations, particularly with the number of keywords you can actually search at any given time. I believe it's limited to 20 terms, and that can be quite. But that I think that's across all the fields as well. So if you're searching for dates, and you're also searching in the title and abstract, and you're also searching in a classification, then it can become quite limited in that capacity.
Yes, and it's also not very good at providing kind of statistical analysis or graphs or
no.
Making sense of the information beyond giving you a list.
No, it's not.
Yeah. And it's also not particularly good in terms of exporting large numbers of results and so on. There is some functionality about that, but it's not the best. So that's what you're paying for, I think, by either paying for a commercial service, and in terms of and I'll let Alec talk about Pat World, which is a nice kind of compromise, I think.
Yes, it's very much a compromise between the free databases and those extortionate commercial databases. It's very much just a comprehensive patent search database that we have developed and use in-house, but it's also available to the public, and it's designed with a very user-friendly interface. such that even somebody with little to no patent search experience can pick up the basics in half an hour, and very cost effective at that. So I would definitely plug that, and as a very fine example of an intermediary.
Yeah. Okay, I'll let Alec speak to this final slide just to wrap things up.
Yeah. So to conclude, I'm going to read the slide right here for this one bullet point. But patent searching is a nuanced art. Like you've said, Jim, it is very helpful when all parties involved have an understanding of what patent searching is, have done at least capable in a small degree to doing patent searching, and that can really help us, the professional searchers, when we're beginning a search, and certainly helps when discussing the progress of a search and discussing the results afterwards. Patent searching has a plethora of uses, as you mentioned before, throughout the entire patent life cycle. All those different search types were all applicable to differing stages of the patent life cycle, and they can be used to really help focus R&D teams, really help focus inventions, as well as saving an unprecedented amount of money. It is important to be wary of the drawbacks I just mentioned, especially if you're doing your own search. Be sure to realize that every tool you use does come with its own drawbacks if used incorrectly, and that, again, such as the searches done by the Patent Office are not always they're not infallible. We can still invalidate patents even though they've been granted, or they still often prior art that's missed, and that patent search databases are expanding and growing every week. And so, like the example you mentioned, Jim, where you found an additional result because machine translations were better, they're constantly improving, and that can happen any number of times we do a search. Machine translations are getting added, more comprehensive, much more thorough translations, as well as older data, perhaps, and more analytics. The most efficient and prosperous searches with the best outcomes I've experienced are where patent searcher, attorney, and inventor all work together and have a high level of communication to help steer the search and to really emphasize results that are they're interested in, not interested in. And that is something that really makes our job much easier, but also makes everything far more beneficial for all parties involved.
Thank you, Alec. And I guess it's probably worth mentioning that AI is on the way, isn't it? It's already here, isn't it, in this field, and will become more so. So artificial intelligence will be doing our searches increasingly.
Definitely, but it's important to note there are definite drawbacks.
I'm sure there are.
AI over human patent searches, certainly at the moment.
That's right. So. That's right. But I'm sure that is going to be in the coming decade or so, it's going to become an increasingly useful tool, isn't it?
Definitely.
Probably not like anything else.
Yes, it's already a useful tool at the moment. So I can, in the next decade, I can't imagine the stage we'll be at.
Okay, so thank you, Alec, and thanks everyone. Do we have any questions?
Yes, I have a few questions. Just let me find them because I've made them during the presentation. So just going from the beginning, how broad do you go with patent classification codes? Do you go with I don't know, A61L, A61L17, or how broad do you initially go when you do an initial, let's say, novelty search?
So that is quite an extensive question, really, because it largely depends on the budget and the subject matter itself. If we're finding difficulty finding anything that's particularly spot on, then we will definitely go broader.
Okay.
And it's a fine art that develops over the course of the search, really. We do a selection of both normally throughout the searching, keep everything as broad as we can, but also certainly focusing down on those really specific classifications that may not hold a particularly large amount of patents.
Okay.
But if we're not, again, if we're not finding anything relevant during the search, then we will begin to increase the breadth of classification use.
Okay, so I understand. So basically, you're saying that obviously it's based on the field. So if it's a very crowded field, you go a bit more narrower. If it's something that's, I don't know, quite novel and there's not much in the literature, you go quite broad to make sure you capture kind of everything.
Definitely.
Yeah.
You've got to take into account the budget as well. I mean, we have to provide an efficient and effective search. So
okay,
if the area is very crowded, then we don't, for lack of a better word, we don't want to waste time digging through a broad classification when we could be searching elsewhere.
Okay. In terms of proximity, kind of like operators, again,
Yes.
what's kind of like what do you start from? Do you start like from, I don't know, 7 words difference between keywords, or 5, or I don't know?
Yeah, a good question, and again, it's very difficult to give a specific answer. I mean, if you're looking for electric cars, then like I said, the more the wider you go with proximity operators, then the more chance you're just going to pick up a patent that's describing a car, but that has an electric component. But then the narrower you go, if you go within 1, then you are going to miss electrically powered cars. So we tend to start, a good starting point is probably 5 keywords, but that is with a caveat that it depends on your subject matter and how you may find patents describe certain things.
Okay. I have quite a few questions. So how do you usually narrow down stuff? For example, I can give you an example of a search that I've done quite recently. So I've not told you anything about myself. So I work at the University of Manchester Tech Transfer Office as a project manager for materials chemistry and physics. So I look at kind of like new inventions from the university, and for the initial stages, I do myself some searches. And for example, I've done a search quite recently about kind of like some method to inactivate some viruses. And there's a word, objet, that can have different kind of like meanings. It can be like a mechanical thing, but it can also be a process. So how do you narrow between the two of them? Because
okay, I understand what you're saying. That is a good question. In those instances, of course, like you said, there are many words that have multiple meanings. If the string that we run, if the search that we start running is bringing up quite clearly irrelevant results, or is throwing the search numbers far too broad for us to go through in the time frame, then perhaps we'll reserve the word for use in classifications, or within a proximity of, if applicable, of course, within proximity of another word that perhaps may be in relation to viruses as opposed to the mechanical aspect, or search within biotech classifications, because in theory, then we shouldn't pick any, if at all, any mechanical related patents.
I understand. Last question. I will not bother you anymore. So I think what's kind of usually the maximum number of relevant patents that you kind of like get back to your let's say clients? I mean, because obviously I don't know, I can start sometimes from maybe 1,000 and then try to narrow it down, but sometimes I cannot narrow it down for less than 600 patents in a kind of like a structural way. So I have to go myself through all the 600 and then pick the ones that are relevant. But I'm not sure what's the kind of like the standard maximum number of patents that you would send to a client.
Generally there isn't, but it does totally depend on the search type and the budget. So for instance, we're going to be sending in theory, we're going to be sending a lot more results for a landscape search or a freedom to operate search than we would for a novelty search, or potentially an invalidity search. We offered a tiered structure to our searches, bronze, silver, gold. So, and we provide analysis then, depending on the tier. But we provide anything. We provide the most relevant results with analysis, and then we still provide everything else we find that is potentially relevant to the attorney. Another step we take is to communicate with the attorney. Quite often we're asked, how many results can I expect to be going through? And while that is a difficult question to answer, certainly at the start of a search, if we begin to find too many, or we start to go over what we feel our client is expecting, then we will communicate with our client, ask, is there any way you'd like us to narrow this down? Would you still like us to provide everything?
Okay. Is there, are you guys kind of like suffering of, like, if for example somebody comes and does a novelty search with you, and you provide some patents that are relevant, and then kind of like the one of the patent offices comes back with let's say another prior art that you guys didn't discover, are you liable in any way towards that, not discovering that patent before?
Well, that is a difficult question. We're very clear that, you know, our company doesn't offer legal advice. So we do the search within the time frame. Occasionally, I mean, the client has some part to play in that. It depends on the budget. Again, the broader the search, the more extensive search we can do, the more results we're likely to find. If the client only has the budget for us to search for a couple of hours, then we can only provide what we find within a couple of hours.
Okay, I understand. Yeah. Okay, so you kind of like try to limit yourself for any liability further down the way.
Yes.
And is there a possibility to tell us what kind of a platform you use for searching, or like what are the most preferred ones?
Sure. So we use a range of commercial databases. That's really the best way to go about it, because each database has its limitations. So we try to offset each of those limitations by searching within multiple different commercial databases as well as free ones. And that, again, that varies depending on time frame and level of search. We do prefer to use PatWorld. That is, it's very easy for us to use. But then we do use many databases for other aspects, such as the patent mapping for Questel.
Okay. Can you name any other?
Yeah, sure. We use Derwent Innovation,
Okay.
Total Patent One. We also use. We search a SPASnet, as well as other national offices, if necessary. The Patent Abstracts of Japan,
Okay.
as one.
Thank you for your time. Sorry for taking so much time.
Thanks.
There's no problem at all.
Thank you,
for your
Daniel.
questions.
Appreciate those
I hope
questions.
I could be of help.
So unless anyone's got a very quick question, I think we've got time maybe for one quick one. Has anyone else got another question? And I should add that if anyone's wants to discuss anything in depth with me or Alec offline, then please do contact us. We're very happy to talk.
Definitely.
But does anybody else have another question? No, in which case I'll just remind you, just to quickly ask you a question. I mentioned at the beginning we've got some upcoming topics we've got in mind for future webinars, but does anybody out there have a burning issue or topic that you're interested in hearing in the coming months? Please let me know.
I'd just like to add, if anyone does have any questions they'd like to add or further discussions, I am available on LinkedIn. But also, please, if you have any patent search inquiries, do email mail@patentseekers.com. It is our general inquiry email address, and we will respond as soon as possible.
Okay, so I think we're just in under the hour. Thanks again, Alec, for joining us. That was really great. Appreciate it. And thanks everyone out there for your time.
Thank you very much, Jim.
And we look forward to speaking to some of our guests again in the future. Thanks very much.
Thank you.
Bye-bye now.
Thank you. Bye-bye.